today, I think it will be done.
Weekly list, page 1, 3 to 5, page 2, 6 to 14, page 3, 15 to 22.
Your Lordship, item number 18. Yes, Lordship. Number 180. For the opposite party, Your Lordship, the
Petitioner Nanti. Petitioner Asantu. That is listed for fresh admission. It is expected to be taken up. Kindly inform your other side.
Item 15, Your Lordship.
15.
Defect, Your Lordship, within a 2 weeks, I will remove all the defect, Your Lordship.
Your name, sir?
15, Vijay Kumar Manthi, Your Lordship.
Yes. Mr. Vijay Kumar Manthi for the item 15. Vijay Kumar Manthi for the petitioner.
Defect now.
The matter was presented before this court on 26/9/2022. Was never listed till 21/11/2025 when it was listed before the Deputy Registrar Judicial for Lojima for removal of defects. 3 weeks was granted. Thereafter, the matter was listed on 11/3/2026 before this bench. More than 3 years after it was filed. For the 2 weeks time was granted, for the 10 days time was granted for removal of defects. Then on 33/2026, the matter was listed. And none appeared for the petitioner. The petitioner was present on repeated calls. Para 3 and 4. The following was directed. Para 3 and 4 of order dated 33/2026. Intimation to the learned counsel for the petitioner through the registry. After more than 3 years of filing, the matter has yielded result. The matter being is in the list under the caption fresh admission is likely to reach. However, the learned petitioner mentions the matter at the beginning of the day's proceeding and seeks adjournment again. Yes, what do you say, Mr. Mahanti?
2 weeks time to remove all the defect. Such is not my knowledge.
In view of 3 years time granted for more than 3 years time for granted for removal of defects, further 2 weeks time cannot be granted as more than on 3 occasions before listing of the matter since 21/11/2025 for the last 5 months time has been granted for removal of defects. To grant further opportunity to the petitioner to argue the matter before this court. It has to be dismissed, Mr. Mahanti. You must understand that after 4 years, listing for over 4 months for removal of defects, you are not removing.
Your Lordship, this case was transferred to me, Your Lordship.
Sir, it's not a question of the case being transferred to a lawyer cannot be a ground. It is submitted by the learned counsel for the petitioner that since the case has been transferred to him, the defects have not been removed for the last 6 months after listing and granting 3 opportunities. The Wakalatnama on behalf of the learned counsel has been filed on 10/10/2023. More than 2.5 years have passed since appearance of the petitioner has obtained change. 2.5 years, Mr. Bharti.
Yes, Your Lordship, which is not beyond my
In
knowledge.
in
Your
any
Lordship.
view of the matter, 2.5 years is sufficient time for removal of defects. However, with much reluctance, without any explicable reasons, the matter is adjourned. Yes. When do you want?
Within,
The matter shall be
within
listed
2 weeks time, sir, I will.
for fresh
resolve the
admission,
case.
so we commencing
4-5
4/5/2026. In this time, something can be heard actually. For adjournments, even I'm trying not to adjourn only on computer, but still then for this,
Which was listed, Your Lord, it was not beyond my knowledge, Your Lordship. I have not seen.
sir, if I record that, that may be referred to the bar council.
Your
You have to
Lordship.
understand, for the 2.5 years, your name is there. When I asked you what's your name, there was a purpose.
Your Lordship.
Yes.
But
Your name is very much there. You are the advocate on record. Don't create a situation where you will be for no reason. If the client is not responding, you are not the representative of the client. The difference between a henchman and a lawyer. Henchman is paid.
Sorry,
Alternative dispute.
last chance, sir. Sorry, Your Lordship.
So why should you say sorry for anything? Have you committed any sin to say sorry?
Sir, Your Lordship,
If you are a
which
believer,
was
to go
wrongly
to the place where your belief belongs.
I have not
I
seen
am not
this.
here to seek sorry from you.
Your Lordship,
You see, I am not that big. I am a small person adjudicating matters, and I have to grant time after 3 years, 2.5 years of filing wakalatnama for removal of defects. Please appreciate that.
Wrongly, I have not
So
seen this.
normally
I
I
have
will
not-
not pass these orders, Mr. Mohan.
In Lodgement Court, the matter was listed. Wrongly, I have not seen this matter.
Sir, wrongly or rightly, sir, only because we intimated you. Okay, registry should not intimate the lawyers and you are practicing in High Court is sufficient time. Now everything is digitized. The list is published online. Usually in my days, you have seen that we used to say that the list was received late, so we could not check the brief. Was it not a ground for adjournment? As the person putting the list falling ill. So those grounds are no more available actually.
Defect
Yes.
Yes, sir, defect. Removal of the defect
And
within.
don't be apologetic for the client.
For him,
Client may be doing nonsense. Why should you? Had ଦିଅନ୍ତୁ ଆପଣ ଅଯଥାରେ ନିଜକୁ expose କରନ୍ତୁନି. Yes, next.
page 4, 23 to 27, page 5, 28 to 35.
Your Lordship, 31. Your Lordship, similar matters have been posted to week commencing 4th May 2026.
31 को 4th मेरे posting करेंगे. Posting कर देले खाली होगा.
Your Lordship, an interim to continue. Those the matters
Entry
posted.
model এটা ଅଛି ଏଥିରେ.
Yes, Your Lordship, this is a after notice matter.
31 Miss
7/3/2025 interim order.
yes, Miss A Pradhan for the petitioner. The matter is listed for admission. It is mentioned at the beginning of the day's proceeding, stating that similar matters have been posted to. Posted in the week commencing
4th May of
4/5/2026. Because item गुड़ाक number गुड़ाक लेखिकी देइयो, so that सुविधा हो. ये trace कर पारियो. बारा. Accordingly, the matter shall be listed in the week commencing 4/5/2026. Interim order as passed earlier shall continue till the next date of hearing. Yes, next.
Lordship, item 32, pray
32.
for an adjournment, Lordship. On behalf of S. Mahapatra, Lordship.
You are Mr. S. Barik.
No, my Lord. P.K. Malik, Lordship.
Mr. P.K. Malik.
On behalf of S. Mahapatra, Lordship.
P.K. Malik, sorry. P.K. Malik on behalf of S. Mahapatra, item 32.
Item 29 mile.
Just a ticket. Order pass କରିବାକୁ ପଡିବ. Because I have to so overload ही confusion होची बोली ସେଥିପାଇଁ ଆଗରୁ order pass କରିବାକୁ. The matter was presented on 3/4/2024. Today is in the list under the heading for admission. Adjournment is sought for on behalf of the Lord Counsel for the petitioner. Accordingly, the matter shall be listed in the week commencing
11-5.
Interim order is also there, Lordship. Lordship, interim order is also there.
Interim order as passed earlier. 32 रे स्टेट बैंक किए अछंती आपण so the matter is mentioned at the beginning of the day's proceeding mentioned actually the matter is mentioned by the learned on behalf of the learned counsel for the petitioner at the beginning of the day's proceeding and adjournment is sought for ओदे एसी चालू नहीं ओदे एटा पर ये 32 रे अपन कहा ना कोई परिवार सेठी वांट मिस्टर अंशुमान सेठी एडिशनल yes item 33 के डेट कर ले अपन डेट कर देगी
We commencing 11/5.
we commencing 11/5
Obligation.
29 में.
29 sir
Let it come to chapter. Yeah. It will be hard on.
ଆପଣ ଅଦର ଷ୍ଟେଟ୍ ପାଇଁ ପିଟିସନର ନାହାନ୍ତି ସେ ଆସିବେ 3ଟା ବେଳକୁ ଆସିବେ ପରେ ହିୟରିଂ ପଡିଲା ବେଳକୁ
ସେ ମୋତେ ଫୋନ କରିଥିଲେ
ସିଏ ଆପଣଙ୍କୁ ଫୋନ କଲେ ତ ବହୁତ ବଢିଆ ସିଷ୍ଟମ ହେଲେ ମୁଁ ବାକି ରହିଗଲି
ହେଲେ ମୁଁ ଅଲଗା କୋର୍ଟରେ ଅଛି
ମାନେ ଆସିବେନି ବୋଲି କହୁଛନ୍ତି
ଜଣେଇଦେବି
29 ପୋଷ୍ଟିଂ କରିଦିଅନ୍ତୁ ଡେଟ୍ କରିଦିଅନ୍ତୁ ତାହେଲେ ଅର୍ଡର କରିବା କଣ ଦରକାର
ଇଏ ଶୁଣେ
ଟାଇମ ସେଭ୍ ହବ 29 ଡେଟ୍ କରନ୍ତୁ ସାର୍
We commencing 11/5.
Item 35, your lordship. This
35
matter-
Mr. Sahoo
This matter become infructuous, my lord. My lord, interim maintenance under challenge. This is petition.
24.
In the meantime, yes,
three ମାନେ 24 ନା 125
24, my lord.
24
In the meantime, divorce petition already allowed.
ପୁରା ଦେଖିକି ଟିକେ ଦିଅ
Sir, memo likhi.
but be particular in giving the name case number date of disposal
Man, already enclosed korchi order ta or details likhi.
correct correct ରଖି ଦିଅ এটা actually file কাढी देखले order रखियो पड़ो so 35 I will mark your presence okay yes and submission
the OP on behalf of Mr. AP Bose.
sir your name
Sanjay Kumar Panigre on behalf of Mr. AP Bose.
Sandeep Kumar Panigre
Sanjay Kumar Panigre.
Sanjay
Sanjay Kumar Panigre.
लिखी रखो 35 ହେଲା items 36 to 40 40 sir
40
yes what do you want
may be taken up after 2 weeks.
not thore hearing आरंभ हेले ऑडिट 3टा बेलକୁ आ पडिबोनी जांच करे will continue some orders matter will be heard
Party is here, my lord.
Mr. Das consent खाली गोटे डेट कर दउछ तने 40 टा डेट कर दियो
We commencing 18/5.
एटा टच किछि हो इतनी बड़ टिल नेक्स्ट डेट का एडजर्नमेंट अछि चल ठीक अछि चलो सुरेश चंद्र दास मिस्टर मित्र हाँ यस यस ट्यूशन यस ठीक है
Item 39, Lordship.
यस
My lord, Mr.
Prasad.
Aditya Verma, my lord, out of station. I pray, my lord, next week any date.
अदर साइड को इन्फॉर्म करंतु
My lord,
Because they are
call
waiting.
करथली से उठेले नहीं फोन.
ठीक अछि सब्जेक्ट टू दे but please ensure that because they are coming around 3 and saying that we could have gone to other court and gone home.
Otherwise, my lord, pick up कले मु पॉइंट जान.
कहि देबे
My lord,
39 टा कर देबे
We commencing 18/5.
my lord, interim order, my lord. कौन?
इंट्री ऑर्डर किछि टच होनी एटा कोन एडजर्नमेंट थिला ना नहीं ते
No, my lord, next week थिला payment of subject to payment 4,000. I continue paying the
तो
4,000.
ऑर्डर देखियो को पड़ियो
My lord, no, my lord, reach करू, my lord. मैं good कर.
आपण इस वक्त कोन टाइम इंटीमेट कर दियो से ऑर्डर ता तो अच्छी है
My lord, intimate में कौन?
कंडीशन वायोलेट हेले सी ऑब्जेक्ट करिवे
Fine.
कंडीशन वायोलेट न होले सी भी काय ऑब्जेक्ट करिवे
Exit, my lord.
अरे मेंटेनेंस ग्रांट एडजर्नमेंट चलला ता पर
नहीं, my lord,
आपण तो दोउछन
First time
नॉर्मल
रे-
जे से एडजर्न कर चलले ठीक अछि
oblige.
I need to pardon, Lordship.
Yes, please.
Item number 23, small modification is there.
23, after notice,
My
the orders.
orders. My lord, item 23.
ঠিক ଅଛି ପଢୁ କେସଟା ପଢୁ ଆଉଟ ଅଫ ଟର୍ନ କ ନେଇ ହବନି ଆଉଟ ଅଫ ଟର୍ନ ନେଇ ହବ
Maybe
Item one,
yes
Item 4.
four yes
10/3/26 as per Lojima report, the page 124 to 121. Sorry, right now that I cannot appear in this case because of the state. So defect
so you I'll mark your presence upon Mr. Mahanti who is there
in state,
just mention on his behalf whatever
some other council will intimate, some other council will appear in this case. That's why. After vacation,
you are now additional
standing council.
date କରିବାକୁ ଚାହୁଁଛନ୍ତି date ଗୋଟେ କରିଦେବେ after vacation
After
କରିବାକୁ
vacation, some other council will enter. That's
so already he has filled up actually substantially
मुख्यमंत्री 29
why.
second week after evening
Oblast.
call କରନ୍ତୁ
Item one,
Wait, please, Your Lordship. Your Lordship, I'm appearing for the petitioner.
yes
Your Lordship had instructed for the status report in the last occasion. The status report is at flag K. Your Lordship.
okay Ms. Charvi for the petitioner Mr. Prem Kumar Mahanti for the ଆପଣ ନୁହନ୍ତି private
So this is private.
private party state
It is not a part.
WPC ଟା CMP ଟା WPC
Lordship.
conversion ହେଇଯାଇଛି
Yes, sir.
order 6 rule 17 reject ହେଲା
Lordship, in this matter, both the parties have filed a compromise petition on 18th March 2019. And in the same light, this case has been disposed of.
date ଟା ଦେଇନାହାନ୍ତି ଠିକ ଅଛି date ଟା ଆପଣ ପାଇଲେ କି
No,
just
Your
go to that
Lordship.
flag the last page I don't find the date actually
No, Your Lordship, the date of
so the
disposal is.
same date for both of us okay yes opposite party none Lorded counsel for the petitioner on behalf of SD Rautray
Yes, Your Lordship.
Ms. Charvi on behalf of SD Rautray for the petitioner order dated 9/3/2026 para 1 2 3 4 this court had directed then 5 this court had directed the London Judge Family Court to apprise regarding the present status of the CP number 157 of 2015. The London Judge Family Court, Barampur, Ganjam, by letter dated 2/4/2026, 2/4/2026, has intimated the registry. Which inter alia has intimated the registry regarding the status, present status of the CP. Last page re achi. It states thus. Inter alia, comma, it states thus. Subsequently on 18/3/19 to neki by observing necessary formalities purchased. The counsel for the petitioner has gone through the report as available in the paperless system. and also submits that nothing survives in view of disposal of the CP. But accordingly, the writ application is disposed of. Yes,
Much obliged, Your Lordship.
yes.
Item 2.
My lord,
Yes, Mr. Basak.
item 2, my lord, I pray for short adjournment because Mr. Arun Singh is the conducting lawyer and he is out of station.
ଆପଣ ତ in station ଆପଣ ବଢିଆ
Sir, the file-
କାହିଁ କରୁଛନ୍ତି ଆଜ୍ଞା?
The file is with him, my lord. Because
4 ବର୍ଷ 5 ବର୍ଷ ପରେ କଣ Mr. Basak
The meantime, filing the additional affidavit where we have stated that he is not entitled to get any maintenance.
it's come 2 weeks after, my lord. Because
enhancement ପାଇଁ fail କରିଛନ୍ତି?
And a rejection.
Their interim application was dismissed. They filed
During
an
pendency.
application under section 24.
You are Mr. Sahoo.
I'm the arguing counsel for the respondent number 1.
Your name, sir?
My name is Anirban Tripathi.
Oh.
I'm the instructor.
अच्छा ଆପଣଙ୍କର वकालत ନମ୍ବର ନାହିଁ ପାୱାର ନାହିଁ.
I'm being instructed by my friend.
Your name, sir?
SK Sahoo.
SK Sahoo for the petitioner. Mr. B. Baisak along with Mr. Anirban Tripathi for the opposite party. अच्छा ଆପଣ ତ ପାୱାର ଯେ ଆପଣ କେସ୍ ଟା ବି କଣ ଜାଣିନାହାନ୍ତି?
ନା ସାର୍ ମୁଁ ଜାଣି ସର୍ଟଲି ମୋ ଫାଇଲ ତାଙ୍କ ପାଖରେ
ପାୱାର
ଅଛି।
ଅଛି ଆପଣ
ସେ ଶ୍ରାଦ୍ଧ ପାଇଁ ଯାଇଛନ୍ତି ତା ବାପାଙ୍କର ଶ୍ରାଦ୍ଧ ପାଇଁ, ତେଣୁ ସେ ଗୋଟେ
ମେଣ୍ଟେନାନ୍ସ ଶ୍ରାଦ୍ଧ ହୁଏ ନାହିଁ। ମେଣ୍ଟେନାନ୍ସ କଣ ଶ୍ରାଦ୍ଧ ପାଇଁ କେସ୍ ର କଣ ଶ୍ରାଦ୍ଧ ହବ?
ନାଇଁ ସାର୍ ତାଙ୍କର
କେସ୍ ଟା ଆପଣଙ୍କର ପାୱାର ଅଛି କଣ ଜାଣିନାହାନ୍ତି। ଆପଣ ଉତ୍ତର ଦଉଛନ୍ତି ଶ୍ରାଦ୍ଧ ପାଇଁ ଯାଇଛନ୍ତି।
ନା ସିଏ କୋଅର୍ଡିନେଟ୍ କରିବେ ବୋଲି ସେ
CORAM, you are being watched. What Mr. Tripathi will take us. The matter is listed for under the headings जो ऊपर लिखिए for referral to the special mediation drive. Mediation विषय रे कौन कहउचंती? सर सिंह आसिले कहिबे?
ଆଜ୍ଞା।
Input order टा कितने annex?
7/12.
Annexer 7.
Yes.
7/12/2021.
Annexer 7 is
Annexer
the-
7.
He has been dismissed.
Madam, have a glance to the prayer you can do.
ଏବେ ଆଉ କଣ ଆଜ୍ଞା? ସିଏ ତ
ଦେଖିବା ନାହିଁ ସାର୍ ଆମେ ଆଡିସନାଲ
ସିଏ ଆପଣ नो वाइट ପକେଇବାକୁ ସିଏ ପି ଛାଡି ପଳେଇଲେଣି। ବିଲକୁଲ ଖେଳ ହବାର ହିଁ ନାହିଁ। ଇଏ କଣ କହୁଛନ୍ତି ତାଙ୍କର କହୁଛନ୍ତି ସାଧକୁ ଯାଇଛନ୍ତି on petitioner prayer for. The petitioner wife, the matter is listed under the heading. Mr. Sahoo, Lord Counsel submits that the arguing counsel. आगे लिखी दूँ तो subject. The petitioner wife is before this court challenging the order passed by the Learned Judge Family Court Balasore in IA number 65 of 2021 arising out of CP number 275 of 2021. Stuff. The CP was filed by the husband in the marriage seeking divorce under the provisions of Hindu Marriage Act. Stop. During pendency of the CP, the wife opposite party had filed application under section 24 of Hindu Marriage Act seeking maintenance pendentalite. Rupees 20,000 for herself and one-time litigation expenses. Not one-time and litigation expenses rupees 50,000. Stop. The IA has been rejected. Therefore, the writ application. Stop. I have rejected, stop, no. Therefore, the writ application under Article 227 of the Constitution of India. The learned counsel for the petitioner seeks adjournment due to non-availability of the learned arguing counsel. The learned counsel for the opposite party submits that upon author kai adhiga file korchundi pleadings ja
No, sir, pleading the
227 re
additional affidavit.
ଶୁଣିବାକୁ ପଡିବ sir ନ ଶୁଣିଲେ କିଛି ହବନି ମୁଁ କଣ କହୁଛି ତାହେଲେ କୁହନ୍ତୁ
ଏଥିରେ pleading
ପ୍ଲିଡିଂ ବଢେଇବା ପାଇଁ ଗୋଟେ ଲିଭ୍ ଦରକାର
ଆଜ୍ଞା।
ଆପଣ ଯଦି ସେତିକିରେ ଯେତିକି ଫାଇଲ କରିଛନ୍ତି 24 ରେ ସେତିକି ହିଁ ସବଜେକ୍ଟ ମ୍ୟାଟର
something has been developed in the meantime.
ଡେଭଲପମେଣ୍ଟ ଟା ସେଠି ଯିବ Modification not free.
under the truthness of the fact by the court mind.
ହବନି ଏଠି ହବନି
Then state-
ଆପଣ modification of the order passed by the
ନାଇଁ।
just family court under
Can-
section 24
my lord, as per the
ଆରେ ମାଇଲଡ କହିଲେ ମୁଁ କଣ ଅଧିକା କଣ ଲ ବଦଳି ଯିବ
ନାଇଁ sir,
ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି any modification of the order you have to approach that court you have not challenged so he has to satisfy the court so don't increase the pleadings
my
the
lord,
learned counsel
additional
for the
affidavit
petitioner
regarding
submits the opposite party submits that
additional affidavit.
as per the instruction of the opposite party he is filing certain affidavits in considered view of this court in a challenge under section article 227 of the Constitution of India by a order passed by the learned judge family court further pleadings should not be and cannot be entertained by this court without any occasion for the same. The petitioners shall rely upon the pleadings before the learned judge family court, those were considered, pleadings and evidence, those were considered. If the affidavit on behalf of the opposite party has already been filed, the same is not accepted for the time being. File question na file karibe.
They already filed case, sir,
The
accepted
same is not
the
accepted for the
statement
time.
given before the.
Now it becomes endless. Then I have to ask him that file reply. This is not a writ petition. 226 no.
statement जो ଦେଇଛନ୍ତି ତାର ଏଇଟା ମୁଁ ଏଇଠି submit କରି additional affidavit.
ସେଟା ଆଜ୍ଞା ଆପଣ ରେକର୍ଡ କଲ୍ ଫର ହେଲେ ହବ ନା ଏଠି କଣ ମାନେ ପାର୍ଟି ଦିଅନ୍ତି
That's the document area of
ଏଲସିଆର ଗୁଡାକ କଲ୍ ଫର ହେଲେ ଯଦି ଦରକାର ପଡିବ କଲ୍ ଫର ହବ
they have submitted. They have submitted before that court that annexing that document along with the additional document.
ସେକ୍ସନ 24 ହଉଛି ଆଇଏ ନମ୍ବର କେତେ
Eh?
ବର୍ତ୍ତମାନ ଆଜ୍ଞା
जो 65
ଆପଣ ଯୋଉ ଆଇଏ ଟା ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି କେତେ ସେଟା
16.
65
ଆଜ୍ଞା।
ଆଇଏ 65 ଆଉ 20 21 65 ରେ ଯାହା ଡକୁମେଣ୍ଟସ ପ୍ଲିଡିଂସ ଅଛି ସେତିକି incremental no aaya every litigation increment hai body jibo this is not incremental pleadings ର concept nahi unless koti kichi darkar thibo and it becomes easier for you also apon jeto order ta defend koruchanti
ଆଜ୍ଞା।
they have to you are just like you are defending they are now the challenging so they have to find out fault with the order apon setota kai jauchanti you start adding pleadings
They're adding, we are nothing adding, only the statement of fact has
ସେଟା
been
କାଇଁ ଫାଇଲ
added
କରୁଛ statement of fact ଏଥିରେ 24 ରେ ଥିଲା ତ
24 ନଥିଲେ।
ନଥିଲେ ତ ଛାଡ଼ନ୍ତୁ ତାହେଲେ
Point out what is it.
କୋଉ ପ୍ରୋଭିଜନ ରେ ଫାଇଲ କରୁଛନ୍ତି ଫାଷ୍ଟ ଅଫ୍
I appreciate what my lord is saying that under 227 the court is only exercising divisional jurisdiction and therefore
akin to revisional
Yes.
227 is little bit smaller and somewhere wider
I
also
completely bow down.
correct
Now what is being filed is something which was not before the family court. That also I agree. But why this file is very simple. In the course of trial,
that Mr. Basak has said
yes,
I got your point
Yes.
but the problem is that during whether the CP is still pending
yes,
CP is pending it is stated by the learned counsel for the parties that the CP is still pending adjudication before the learned trial court. So whatever was evidence, suppose he is able to get over the fast hurdle because it's a reasoned judgment.
yes,
So he has to get over the fast when the petitioner here
yes,
has to get over that fast part. Then if required, because he also now the issue will be that once I start admitting, let us assume
yes.
I accept your pleadings, then he has to reply.
That's right.
Then it becomes an endless effort.
I understand that, but why it is relevant? May I just point out? Her petition is on the ground that she has no income and that she has to support her parents and have no income. In the
Please
cross.
don't get anxious about her ground in the writ petition. What was her prayer and pleading in 24?
Yes.
That much.
Similar.
So you have to say one line
Yes.
that beyond section 24 application, she cannot travel.
That's
Because what I was asking for modification, Mr. Boysak,
yes.
if you want seek, they can also seek modification. But this matter cannot be taken in the original side by this court. Please appreciate that.
I
So both ways. I mean, it is uniform rule.
All
Yes.
right.
So please be patient. Yes. ଆପଣ କାଇଁ ବଢଉଥିଲେ ବର୍ତ୍ତମାନ ଆପଣଙ୍କର ଆହୁରି difficult ହେଇଗଲା. What I hope you understand what is being discussed. Once you started adding points or taking new plea before the writ court,
We have
27.
not added in.
So you please stick to your pleadings in the 24 application and how it has been dealt with. Whatever evidence pleadings is there, you stick to that. Now you are giving them that opportunity. Unwittingly or whatever, but you are giving them that opportunity. Yes. Give a date to Kevin. Matter shall be listed in the week commencing 11/5. It has not been admitted. Upon appeal question. Notice it.
Notice it.
Mediation ପାଇଁ କ'ଣ କୁହନ୍ତୁ?
Medicine ପାଇଁ ସେ ଆସିଲେ କହିବେ.
By next date. ଠିକ ଅଛି. By next date, the learned counsel for the parties shall obtain instruction regarding reference of the matter for special mediation right 2.0 mediation for the nation. Because unless you convince your respective clients, there is no point in sending. Already the system is overburdened. Mediation,
Sir, I don't think there is any going to be
No,
used
sir.
for mediation because the parties are at.
Usually in maintenance, there is no scope for mediation. So let us see.
May I request my it on 18th of May instead of 11th?
We commencing 18th May 2026.
I am always.
Item 3,
Mr. D.N. Misra for the petitioner, Mr. P.K. Mahanti. So Mahanti, you are there, or Mr. Lenka? Yes. Usually when D.N. Misra appears, D.N. Lenka appears from the other side. You have to be careful in that. Yes.
This claim of RACP was rejected by under Annex 12 by that page 87.
That's Saraswati Bhoi State versus Saraswati.
No, well, that is on contest, my lord. But in this only Rule 9 is applicable to Rule 9. There is large number of judgment.
Yes, Mr. Mahanti, have you examined that aspect?
I have got
Because
the
I have
judgment.
noted Mr. Lenka's submission that it is covered by State versus Saraswati Bhoi.
No, well,
I'm
that,
sorry, Mr. Misra submitted.
but that is Rule 9 only, applicable to Rule 9. I have got the judgments, my lord. I have given, let him take any date from there. Applicable to Rule 9, my lord.
So that preliminary issue regarding State versus Saraswati,
Well, that is regarding only the fixation of pay, my lord.
you are no more pressing that.
No, my lord, I'm not.
So they kindly make your submission.
But actually, my claim was rejected on page 87, my lord. My claim is that I am par with government college lecturers, teachers, my lord.
So you are challenging this order of rejection.
Order of rejection, my lord.
But since
While
2019 notice has not been issued,
No, my lord.
not listed.
Not listed, my lord. Only provision of rule applicable to Rule 9(1), my lord. They had granted earlier under Annex.
And there is no scope for any appeal or any education tribunal or interdepartmental appeal.
This is a policy decision, my lord. My lord,
Policy decision.
my lord.
Yes, Mr. Mahanti, you take notice. Say I have order for rejecting your claim.
I have given the judgments also in favor of mine. Let
them file.
Well,
You also don't be impatient. Let us see what stand they are taking.
My lord.
But since you are saying Saraswati Bhoi, you will not, then I have to sue. Little appearance check. Hard learned counsel for the petitioner. He refers to the earlier order dated 9/3/2026, wherein it was observed, wherein his submissions, not observed, wherein his submissions were noted, as it was submitted that the case of the petitioner is covered by the judgment of the division bench of this court dated 24/6/22 देखिए लिखे गए citation. Order number 932. Stop. On the said date, notices were issued and the learned additional government advocate was requested to respond to the submission made on behalf of the learned counsel for the petitioner regarding applicability of the decision State versus Saraswati into bracket Supra. So, it is submitted by the learned counsel for the petitioner. It is submitted today that he will not rely on versus Saraswati for the present. Stop. In view of such submission, the state shall file their counter in response to the writ application. How much time, Mr. Mahanti?
4 weeks.
Within 4 weeks, as prayed for, upon serving copy thereof on the learned counsel for the petitioner. The petitioner shall have liberty to respond, liberty to file rejoinder in response to the counter within 3 weeks. Within 3 weeks thereafter. List under the heading for admission. After the pleadings are complete, liberty to mention.
Right.
Yes, next please.
Item 4.
Mr. Aravindo Mahanti for the petitioner. Mr. Prem Kumar Mahanti for the opposite parties 1 and 2. It is submitted by the learned counsel petitioner that he withdraws his power as he has been impaneled as a government counsel in the office of the Advocate General during pendency of the writ application. So it is further submitted that further time may be granted to enable the petitioners to engage any other counsel. Stop. Accordingly, the matter shall be listed in the week commencing on 30/6/2026. The petitioner shall have liberty to engage any other counsel by obtaining consent from the learned counsel who was appearing earlier. Stop. Interim order as passed earlier. Interim order dated 23. Interim order to nahi bole the. ये physical file था जब घंटा ये बोलने नहीं बहुत केस तो इन्फॉर्मेशन अरविंद भारती तेरे इंटरिम ऑर्डर किसी नहीं ते डिफेक्ट रिमूवल पर लिस्टिंग आओ हे yes next Mr. Das.
Item 5.
But this is an appeal under section 74.
He asked for the appellate. You are along with Mr. Senior. Mr. S.K. Das, Senior Advocate, along with Mr. P. Das for the appellates.
On the last occasion, my lord, the delay was condoned by your lordships by putting some cost that I have deposited already. That is in the my lord cause list, the note. But along with that, some other notes are there, my lord, regarding the correction of from the order sheet. That is there, my lord.
That has now become a regular feature of what can be done. The registry has indicated inadvertent typographical error. Inadvertent typographical error, which is usual for Secretary Mr. Datta, as he has again typed the order number wrongly. So, after order number 9, the order number should be 10. It has been typed as 7. Stop. No, the also side of single inverted comma single. Para accordingly it is directed number in order dated 16/3/2026 shall be corrected in hand by correcting 7 as 10. The correction shall be carried out as follows. As that the learned counsel for the petitioner refers to, the learned counsel refers to the order dated 16/3/2026, paragraphs 6, 5 and 6. Stop. It is submitted that the conditions imposed for continuation of delay have been complied with by the appellants. Stop. The office note indicates that the amount as directed for continuation of delay has been deposited in the Odisha High Court Welfare Fund. So, Odisha Association, Odisha High Court Bar Association Welfare Fund. In view of the compliance of the conditions, the delay which was directed to be condoned is hereby condoned. Directed to be condoned by order dated 16/3/2026. This is hereby condoned. IA number 431 of 2026. There. 2024. IA number 431 of 2024 is forced up. Notice be issued to the respondents in appeal. Stop. But you have not made the...
My lord, I have a small prayer regarding that. On the last occasion, Lordship was asking that is there any requisition authority? Because unless they have added to that, the entire award will go. It is a nullity. So that, my lord, I have, my lord, verified that is, my lord, the requisition authority is Deputy Chief Engineer Construction, East Coast Railway.
Please.
That is there. But unless Lordship admits it, I cannot file any additional, my lord, petition to implead that.
No, unless you make a prayer, how I will...
My lord, after...
Because I understand, I have tried to cut it short also. Whether, but you have to make that prayer.
My lord, I'll make that prayer. Lordship may admit it.
It is submitted by the learned counsel for the appellant that it prays for, he makes a prayer for, he may... sorry, last quote, sorry. I is covered and disposed of. It is submitted cutting the learned counsel for the appellants seeks leave to implead the requisitioning which had sought for acquisition of land. Stop. In view of the judgment of the Constitution Bench in Uttar Pradesh, so and so, Awas and Vikas Nigam, the requisitioning authority, public project proponent, should be heard in deciding matters where quantum of compensation is questioned. Stop. In the present appeal, amount is sought for is enhancement. In the present appeal, the land oustees seek for enhancement of the land acquisition compensation. As per the order of the presiding officer, purata likhiyo puro, Nara jo likho. Page 9 dekhi likhiyo. That is officer. Under section 64 of the Right to Fair Compensation, purata likhiyo. So and so Act 2013. For acquisition, for acquisition of land for the Khurdha Road - Bolangir, new broad gauge rail link, Bolangir. Stop. In view of the position in law, the prayer for impleading the requisitioning authority, public project proponent, is allowed. कौन बोलते हैं आउथरे टाइप करे पड़े हो नहीं ना तोड़े ऐड कर देवे इतनी जगह चे ऐड कर दियो तो the petitioner the appellant counsel for the appellant is permitted to carry out addition of party in the title of the appeal memo by indicating the name of the officer as well as the official address clearly. Stop. Notice be issued to the newly added R2 by speed post with registration and proof of delivery. Requisites for issuance of notice to the newly added R2 be filed within 5 working days. Seven within we filed within 7 working days.
But usually the same.
Mr. Prem Kumar Mohanty, Lord Additional Standing Counsel, upon advance copy served appears for the R1. Upon extra copy darkar?
No.
Connected papers file करचंती?
No, for R2 pilot, usually pilot the central government councils are appearing.
No difficulty
For East Coast Railway.
But the thing is that you have to serve an extra copy.
My lord, I will, if your lordship.
So like waves notice कर देले, no further notice be issued to R1. R2 रे गोटे सपारा करे add करो. It is submitted by the learned counsel for the appellant that he may be granted leave to serve extra copy of the learned central government counsel who usually appears for the
East Coast
Railways, comma project proponent. Stop. Liberty granted to the appellant to serve extra copy to the learned counsel appearing for the East Coast Railway. Usually appearing for East Coast Railway. Learned counsel usually appearing for East Coast Railway, apart from taking notice as directed. Upon list for admission after service return, liberty to mention. IA 431 disposed of. IA 431 disposed of. Then 455.
455 was for exemption.
That has been allowed.
That has been allowed, kept in abeyance.
Kept in abeyance for the time.
For the time, that has to be there.
चलो आप कुछ ऑर्डर लिखा है पहले 431 के ऊपर डिस्पोज ऑफ होगा यस आ गया हां अपन एक carry out the necessary correction. The addition of the parties shall be on the signature of the learned counsel for the appellant and shall be countersigned by the court master. Yes, next please.
Item 6.
Yes, please.
Well, this is for fresh admission.
Yes.
I'll just put the facts in.
Mr. Singh.
Yes.
Animesh Singh for the petitioner. Yes.
The brief facts are that in 10 the marriage was solemnized.
What you are challenging, sir?
I'm challenging the order of the family court at page 15.
Yes.
The last paragraph I would read. That it is directed that the respondent wife will visit the minor son on each Wednesday in between 6 p.m. to 8 p.m. and from 10 a.m. to 12 noon on the each Sunday in the residence of the petitioner.
Yes.
My only short prayer is that the place of visitation is in the residence of the petitioner. That may kindly be changed to a neutral place because the wife has already.
Did you make such a prayer before the learned court who had adjudicated?
Yes, my lord.
Your petition.
It was done part of the order.
Your prayer before the learned trial court. This custody application has been filed by whom?
No, custody. The child is in my custody only. The father's custody.
Custody of application has been filed by. Your answer should be by the mother.
Yes.
Custody, the child being with the father. The custody application.
There is no custody application. It is in the divorce petition. The wife has filed for a visitation right to the child.
It's a custody application.
Yes. So visitation has been allowed. I have no objection to that. Only the place is residence.
So when visitation application was filed.
Yes.
What is the provision?
It was filed through an IA by the wife.
Which is the provision?
It's 24 is for maintenance. So visitation
Section
is
26.
26.
So 26 application, did you file your written statement?
It was filed. It was previously also ordered twice. The first portion of the order.
So have you sought for modification, the change of place of vegetation before the learned trial court? You saw that.
No, that is not.
So then you are wasting court's time and your time also. You see, you must understand that this court is not the subordinate court or the.
Understood.
Both ways. As far as the pending cases are concerned, if you are agreed by any order, so you will be agreed when your prayer is rejected. Please appreciate that. So section 26 modification or your written statement have been not taken note of, then fine. But you fairly say that, I mean, after this deliberation, you also, I mean, to that extent, you consider that you never, I mean, ask the court to pass a particular order.
I just read out the first part of the order
No,
by
no,
the
first,
family court,
before
where the
going
court
to
has
the court's
observed.
order, you have to be sure of your pleadings.
Yes, ma'am.
Court is not passing orders in abstract.
Let me just first read that
If
portion
you
because the
will,
court
the
has
problem
observed
is
that part.
After you complete half an hour, I start the asking you question, this will be the problem. The entire effort will be wasted.
I understand, ma'am.
So
And
you
the first
take your
part, the
time.
court
You
has
must
observed
understand
this.
that you have to tell this court,
Yes, ma'am.
sitting in division or 227, that this was the pleading, this was rejected, or this was my stand, it was not considered. So that part you are saying it is not there.
No.
So then you go ahead, whatever you want.
The court has actually observed this in the first paragraph of the order because it was twice modified earlier.
Twice or 10 times, we are not considering. So are you taking exception because it is twice modified? It should not be.
No. That I'm not saying. I'm just saying it was twice modified, observed by the court.
Legally nuanced.
Yes.
You must not make superfluous statements which doesn't help us.
I understand. Them.
Yes. So please make your submission. But ultimately you have to show this that what was your stand and
the first paragraph of the order, it says the petition dated 3/2/24 filed on behalf of the respondent to direct the petitioner to comply the order dated 2/1/24 and the petition dated 3/2/24 filed on behalf of the petitioner to modify the order dated 2/1/24 are being disposed of by this common order. So the notification was filed earlier also. I have already heard the parties. It is submitted on behalf of the respondent that she had been allowed to meet her minor son twice in a week, preferably on Wednesday and Sunday at a suitable time convenient to the parties for 2 hours. But the petitioner husband is not allowing her to meet the child on Wednesday, though she is meeting with the child on each Sunday. So the husband was allowing the wife to meet the child. It was twice modified. Subsequently, while this modification was ordered, the Honorable Court at the last paragraph has added that in the residence of the petitioner. That is the only issue.
the problem is that is the only, I am not, I can't correct orders like this. I am not exercising 26. In fact, I do not have power also exercising 26. The original power is with the court. So now, if the court does not exercise 26 modification or 151 or whatever 141 CPC inherent power, then you have a case. So that is the effort for the last 10 minutes from you to know that what was your case which has been rejected or not considered. Where is that?
So this is the first
What
part of
your
it.
pleadings to that, or whether you have, drawn the attention of the court regarding anything which you are agreed.
No, modification, I have only submission with regard
Please
to
appreciate that this should not be, and this becomes then this problem. This remains a problem for you. And if you do not draw the court's attention by filing appropriate application for modification or any condition, so that it can be churned out by the court. And now the court may not exercise or may exercise wrongly, or you may be dissatisfied, either of you. So that issue is yet to, that situation to be reached by both the parties. So what do you want? Dismissal or withdrawal or what? Or order to be passed and giving reasons?
For notice, maybe you should.
No. That should be dismissed. Our Lord and Counsel for the petitioner at length. The petitioner, perhaps we are not following.
I understood. Because
it is court file kariya katha. application.
modification, I would like to submit. There is another modification also which was
अरे
preferred.
sir, आपण 100टा modification file करतो. Let us be pointed approach. Vegetation right at home, you want to you are not agreeing. So was that considered by the trial court? That's the first thing I have to say. That has not been considered.
It has not been considered.
It cannot be, because it is not in abstract.
So this 3-2-24 was there, then 2-1-24 was there.
You have to approach the court.
That has been approached.
Before approaching the court, don't never venture to get an order on merit, dismissing your application. As a lawyer, that I can advise you.
No, I understand completely. The only thing
if you want, I'll dismiss it on merits.
That is already. If it is dismissed, I'll have to comply with the order. But it is
No.
practically impossible, because
You are since how many years you are practicing in this branch?
16 years.
16 years. You should have been. You are arguing as if you are practicing for 6 days.
No, I don't think so.
Yes.
No.
Because you are not able to find out the petition also, where you have told the court that please modify this, and then you want that it should be.
I have mentioned there are 2 modification petitions filed in.
Sir, I'm not asking how many. You show me the petition where you have made the prayer and that has been rejected. After 16 years of practice, you are saying that not filed. So what the court will do? Did you draw the court's attention by filing petition, or it was your contention before the court in the written statement or whatever objection? Was it?
No, it is not there.
Then, okay. The petitioner husband is before this court, challenging the order dated 29/6/2024 passed by the allotted judge. Court. You take your seat. I'll take some time and dictate it. Order dated 29/6/2024. In CP number 143 of 2024. The CP. Yes, Mr. Acharya?
I was suggesting let him withdraw.
No, you are not 61 years. Have you practiced for 61 years?
No, I was just helping him that better you withdraw and file a application.
Obviously, there is no adjudication on merits. There is no adjudication on merits.
Dismiss them, he has no chance. That is what I was just suggesting.
Yes, Mr. Singh.
Yes, I would also like to suggest that there was another modification petition which has been filed before the court. I understand.
By whom, sir?
By the wife, to comply the order.
Husband by appeal court.
Yes. That I have also challenged.
Filed any application by the husband who is seeking modification of that place.
Yes.
And fortunately for me, though I have not practiced, I have been dealing with this matter very recently. Wife filed that it should be a neutral place.
Yes.
The court directed it should be at the R&B bungalow. R&B, what is that? Section bungalow. Then the husband then the wife herself came to this court. So these are the strange things that is happening.
I understand this.
So in fact, they do not know what they are saying. The court must have thought that how it can be in a confined place. Can be the place of the residence of the wife or husband. Both are objecting. They may start fighting in presence of the husband also. I mean the child. The child will be looking like this, that both the parents have started fighting. That is also happening. In some cases, in courts, it has happened. So now the wife again comes to this court and says that why it will be at inspection bungalow. It is your prayer. It is your prayer that it should be at a neutral venue. And outside it is not safe. All these things. Now the state is also entitled in these cases that they should provide the inspection bungalow for. So these are strange things. So if you have not filed, avail that chance. That Mr. Acharya's suggestion is.
In that case, I would like to
file a memo. Because again, you do not know what the wife will tell you and husband. Here the husband will tell you. Memo diyo. 143 of 2020. The said order dated 29/6/2024 emanates from the petition dated 3/2/2024 filed by the respondent wife in the CP seeking visitation and contact rights purportedly under section 26 of the Hindu Marriage Act. Now, the CP has been filed. CP upon file करचुन ना wife file करचुन.
Husband has.
The CP has been filed by the petitioner husband. Petitioner herein dash husband in the marriage. Seeking divorce under section 13. 13 of the Hindu Marriage Act.
Yes.
Which is pending adjudication. It is taken by the learned counsel for the petitioner dash husband that आपण त्यांनी घरକୁ ଆସିବାକୁ ଚାହୁଁନାହାନ୍ତି wife କୁ.
Because she has filed a domestic violence case against me and
ଆପଣ
my
ସେ
father.
domestic violence ରେ ଜିତିବାକୁ ଚାହୁଁଛନ୍ତି ନା ହାରିବାକୁ ଚାହୁଁଛନ୍ତି ଆପଣ against ଯୋଉ
ଜିତିବାକୁ ଚାହୁଁଛନ୍ତି.
Justice Sinha would have been there, would have been interesting. He used to analyze this way. His senior was a barrister actually. So he has seen his senior barrister Bimal Chatterjee asking his client that who told you to take this stand evidence, because he is a seasoned Justice Sinha also. He original side, as you know, in Calcutta they have original trial jurisdiction. So he used to ask these questions. So this should be your first line of defense, Mr. C. If it is already there on record, in domestic violence, your first line of defense is that I should not actually substantiate the cases.
I was coming to that. I was going.
You should not actually. If you, so then you must realize what you are arguing. You always look at the interest of your client.
I understand. I was coming.
So if you want to win the domestic violence case, you should not challenge this order. Please appreciate where you stand now.
I don't understand. If
you could not understand, okay, you think about it, reflect on this, because we are not discussing. It is something parallel happening. Regarding your case, I understand, sir. Mr. Acharya has also came into here.
No,
but so that is a parallel thought process, because you said that she has filed a domestic violence case. So I do not want she should visit, to my place, directed by the court. So that you please reflect upon in your spare time. When you are, after you complete the day's work, it may be hectic, so many cases, so many courts. You reflect on that, what I say. Okay. That the husband is not objecting regarding the visitation and contact rights granted to the wife as per the conditions imposed. As per the direct, not conditions imposed, as per the directions contained in the order dated 2/1/2024, dita 2/1/24 और 29/6/24
3/2/24
3/2 order ହେଇଥିଲା
3/2/24 ଗୋଟେ petition file
petition order ପଚାରୁଛି the contact
order is
visitation is as per the order dated
what is it 29/6/2020
ତା ପୂର୍ବରୁ 2/1/24 ରେ ଗୋଟେ order ଥିଲା
2/1/24 ରେ ତା ପୂର୍ବରୁ yes
correct. So those are the two orders or any more orders?
Thereafter another order is there which I have also challenged, which will probably come up in the next week.
2/1/24. Think about it, these things. 2/1/2024 and 3 Para no, sentence are completed. But the place of vegetation as directed, that is residence of the petitioner husband, is objected to. In response to the submissions of the learned counsel for the petitioner, on being asked whether the petitioner husband has sought for any modification of regarding the place of vegetation and contact before the learned judge family court by filing appropriate application, it is submitted that no such application has been made. Stop. Further, on being asked whether in response to the application, wife, that's mother of the child, any objection, oblique written statement was filed indicating regarding the place of visitation and contact. The answer is also in the negative stuff. At this stage, the learned counsel for the petitioner files memo indicating that the petitioner will not pursue the present application and he shall approach the court seeking appropriate relief. The memo states thus. The memo does states thus. The memo shall be taken on record, scanned copy be updated, the petition stands disposed of. Yes.
Item 7.
Please don't take it personally. That is a purpose. Because
I'm not taking it personally.
No, because when I said, because these are the daily events, as a family court counsel, they will want to change conditions, these things. So that is how I said
No,
that.
the facts of this case are totally different. My lord would have appreciated if I would
No, I asked you that you complete your submissions, but you again said that I have not filed.
No,
You complete your submissions.
My lord,
Then I have to dismiss on merits.
I understand.
I can't time like this.
Understand. Whatever
If
is ordered, I bow down
no
to it.
choice, please don't be under the impression. I have the anxiety of spending, because I have spent 1.5 hours in a custody in a maintenance application. After 1.5 hours, then when I start asking these questions, basic questions, what was the amount, what were these things, then everything fizzles out. So entire day is gone. Senior advocate argued for 2 hours on another CPC that he cited a decision that at the stage of initial hearing also it can be decided, because it's a mixed question of fact, the place of again that fizzled out. So that creates a problem in a fresh admission matter. Without the petition being here, I cannot interfere.
Here the child is in my custody, in the custody of the
Sir,
father.
that you have told me after I asked you. I don't forget. I have some difficulty in forgetting the facts. So that is how the contact and vegetation rights are what your place has been directed by. Understand why, in the context, why the court is asking this. The child is with you, that maybe the age of the child is
15 years.
15 years. So there is a possibility that I don't know what happened at Delhi, because there is no pleadings regarding that. What should be the place, whether the wife has sought for it, what was your response, why the court directed this, all these things are to be part of the record, at least pleadings. So that is how I cannot interfere. If you want, it can be dismissed on that ground.
No, I'll file a fresh application.
No, what trade you want to plead? That is, you be satisfied that at least you have placed the matter.
Other facts that I would...
Yes, because the child, consumption of time impacts the entire day's proceeding. No, not exactly that I want to deprive you of your hearing. Because you argue for 1.5 hours, like I gave you the example. Then on the point of scope of revision, whether I can interfere in 227, it cannot work out. Then the entire time is, your time is also precious. I think. Yes. So what do you want to say, please?
The thing is that the wife filed the domestic violence case after 3 years of instituting the divorce petition. And the child is also suffering from ADHD and autism, for which the father has taken the custody. The mother was never willing to take the custody of the child.
Before making a statement, I'll tell you, please complete, since you are so much of anxious that you complete.
The visitation right is only to harass the petitioner because the place of visitation is at the residence of the petitioner. The husband is staying with his
That is the way you are looking at, her husband is looking at it.
No, it is the fact of the matter.
No. As a lawyer, you are looking at that, or
yes, as a lawyer also I would look
or you are
at
just
that.
narrating the husband, because
No, I'm not narrating.
As I have been telling that they tell a sad story, दुखभरी कहानी सुनाते हैं.
Every client.
So lawyers job is that to give it legal nuance.
Understand.
Correct. So what you are saying, is it your perception or husband's perception?
No, it is my perception also.
Your perception.
Yes.
Okay. That is a debatable issue then. The court has a different perception.
I'll file a fresh application.
So again, please remember that you are the counsel for the domestic violence case.
Yes, right now.
Please remember that you want to win that case.
Definitely.
Yes.
I'll make
So when you get some opportunity which will help you in winning the case, don't lose that opportunity. You have made that it is filed 3 years after filing of the divorce
petition.
So that's a good point. Yes, next.
Item 7,
Mr. Devashish Panda along with Mr. Dhirendra Kumar Mahapatra for the petitioner. Opposite party black.
Your Lordship.
Yes, please.
Your Lordship wanted me to inform the court as to how I intend to secure that amount.
Yes, please.
Lords, he is a pensioner who draws a pension of 9,900 net deductions. That apart, he has got a insurance policy.
Pensioner, you give the details of the pension. That will help the court.
Lords, he is a pensioner since December 2019.
How he retired? What
He
was his
retired as a
situation?
cook, my lords, in the CRPF.
Cook as CRPF. So you give his pension details. That will help. That you just ask to give the pension details. That may help in.
I have got the copies. I'll file by way of an affidavit.
The learned counsel, Mr. Podda, learned counsel for the petitioner. He refers to the order dated 11/2/2026. Stop. In response to the paragraphs 6 and 7 of the said order, it is submitted that he has received instructions to the learned instructing counsel that the petitioner is a pensioner, having retired as a cook, working in CRPF. The details of the pension papers he shall file supported by affidavit of the petitioner. How much time?
I can file it by tomorrow. Your Lordship may call this day after tomorrow because the petitioner is not in a position to come and file affidavit. He is paralyzed and bedridden. I'll ask his son to come and file. Your Lordship may also record that he is paralyzed and bedridden.
It is submitted that the petitioner is suffering from paralysis and he cannot come to file affidavit. His son shall file the affidavit enclosing the account statement, enclosing the pension papers.
I'll do it by tomorrow. I'll file it. Let it come there.
The affidavit shall be filed within 2 working days. List on list on 17. 18টা working day আছে?
না,
না 17. 17.
item 8,
পাস ওভার করতে হবে ওটা কি? মান্তি পাস ওভার? ওকে।
item 9,
Make regulation.
Ms. Dipti Rekha Nanda for the petitioner, opposite party black. Yes, Ms. Nanda.
My lord, the husband before your lordship, my lord.
Yes, please.
We are challenging the judgment passed in the family judge Bhadrak, my lord, in criminal proceeding 212 of 23, my lord, awarding the maintenance for 2 children of opposite party number 2 and 3 for 14,000 and for lady wife 5,000. Meanwhile, the lady already filed execution. That notice will be received by tomorrow. I am not filed before your lordships. I am challenging.
Unless you pay the amount, I am not interfering.
My lord, I have no objection to pay the OP number 2 and 3 children.
Take that stand before the trial court. I not have a rehearing of the 120.
No, my lord.
So
Husband.
if you have taken that stand before the trial court,
My
that you like to pay the child and do not like to pay to the wife,
My lord.
then show your pleadings and the evidence. That much I can help you.
My lord, kindly call this matter on Friday.
Not Friday.
Monday.
Not Friday.
Coming Monday, man.
No. Today I'll pass the orders with these reasons what I have told you. Because this can't be a fishing expedition.
My lord.
Because I won't want to
Then
that today something,
My lord,
next day
present
something. So
petition.
if you are saying that, I'll record that. You do not want to. So you have denied your liability to pay before the trial court. So what was your
No,
pleading and what-
not denied, my lord, not denied.
then-
Fine.
So
After
then I
hearing-
can't, I am not
My
asking
lord,
the trial
after,
court.
my lord, after hearing the learned court below
No,
awarded,
it's not question of hearing. The court has heard you.
my lord,
Court
I have
has
filed
gone
the,
through your pleadings.
my lord,
So you saw that. It is not that court, how the court heard it.
my lord.
So you have at least what is on record, the
Right.
evidence. When you are denying not to pay to the wife in the marriage,
Did-
then what is your stand?
On the ground that she is affluent, she is running a petrol pump.
So have you checked the decision on this
Yes, my
affluent
lord.
and running petrol
Yes,
pump?
yes, my lord.
So which decision you have checked? Court has dealt with this. Suppose now the industrialist, a big entrepreneur of man of 100 crores or 1,000 crores go for filing a maintenance, whether she will be awarded. Court has dealt with that. This is no more res integra.
My lord, but
So
the
which
present,
decision you have
my
taken?
lord, the present petitioner's income is he is a LIC agent.
He can claim maintenance from his wife. That we are not discussing. Your ground is that because your wife is affluent, she is not entitled for any maintenance. So this has been decided by the Supreme Court.
My lord,
It is not left to the High Court for imagination
my lord.
or to be argued. So what is that decision?
Decision, my lord, so many decisions. Meanwhile, so Neha and Rajan decision
So
is the
it's very
most
clear
decision.
on that.
But on that decision, the present opposite party number to the wife, not disclosing not supporting any
The
document.
problem is
regarding-
that Rajnish versus
No.
Neha doesn't say
My
that
lord,
if the wife does not disclose, then she is not entitled.
no, not
That's the
entitled. But
problem.
my
125,
lord, I have my
125 extensively dealt with.
my lord.
So there is nothing
My
left
lord,
for
my
my
lord, I have,
interpretation or your argument.
no, my lord, I have annexed the annexure to the notice from a
So
income tax
first of all,
department,
you
my
have
lord.
to show the pleadings.
My
What
lord.
was your stand and what was your evidence? If you are serious enough to argue the matter, do that. To an adjournment, record and adjournment.
Only to Monday, my lord. I mean,
So Monday I cannot. Today is the best day. You must understand.
pleading the more जो affidavit जोड़ा दी थी सेटा ମୋ पाखरे ନାହିଁ. Only
Then
wife
that is your that. So that I
wife
cannot.
ଅଛି.
It is not at the choice of the
My lord,
petitioner that went.
my lord, kindly to see the impugned judgment, impugned order.
Impugned judgment I will definitely see. I do not pass orders without looking at the judgment. But please help me looking at your pleadings.
No,
and
I am ready. That is my case. I have to prove my case, my lord.
So what was your stand before the
But
trial?
my hands
So
are tied. My hands are tied. But now the pleading of my lower court record not available with me.
That's the problem. You should have watched that.
Yes,
Before
my.
taking the
That
grounds.
point I'm sorry.
Because
That
now-
point I'm sorry.
No, you need not. Why should we
On that point,
apologetic?
sorry.
The problem is that these things
I
have
have
not been left out.
No, I have annexed the
From the purview of Rajnish versus Neha, these have not been left out. Because suppose now I am impressed or may I have a liking for a particular lawyer, I start
But
dictating
tomorrow, my lord,
that since the husband is, the wife is earning and she runs a petrol pump, she is affluent, she is not entitled. That will be wrong order in view of Rajnish versus Neha. Second point, she has not disclosed her
my
income.
lord, everything mentioned in the judgment, my lord, order. The learned court below, so many, kindly see the para 13 of the judgment, my lord. Para 13, as per the petition number 1, she has no sources of income. She is not income tax assessee. She has not find any copy of income tax return.
Who alleged this, madam?
My lord,
Who alleged this that she runs a petrol pump?
my lord,
Who alleged before the trial court that she is running a petrol pump, affluent?
the husband, my lord.
Husband.
My
So what was her proof that
My
I've been
lord,
asking you?
My lord, see,
So
on
that will
her
clinch your case.
My lord,
Would
no, my lord, on her statement, she is admitted 14 passbook running on her name, my lord. She is,
Madam,
my lord, she is
running of
managing.
passbooks, accounts
My lord,
will not help you unless you
actually-
take that plea,
My lord,
show that she is running a petrol pump. That is enough. This judgment will be stayed right now. That much you have to show that where the court has dealt with your statement. It's not that difficult also.
My lord, para 13, it is by that she is receiving.
No, your statement.
My
Your
lord,
statement that you.
my lord, the lady itself admitted that running
You
a
are not
petrol
getting
pump.
the point.
My lord, the lady itself
Your
admitted.
assertion you have to prove.
My lord, lady itself.
Your problem. I'll record that. I have to record and
Lady,
check that.
my lord, the judgment lady itself admitted that
Lady
she's running a
admitting that
petrol
she's a
pump.
millionaire and
No,
she
no,
has
see,
to say that.
running a
You
petrol
must
pump, she
understand.
admitted.
You must understand that.
My lord, she admitted.
Suppose the lady
running
says that I am a
petrol pump.
millionaire but still I seek maintenance.
My lord, lady admitted on her.
By saying lady admitted 10, 20 times, I understand.
Yes,
I'm saying to the extent, I'm going to the extent that the lady stated before the trial court that she is a millionaire.
She also submitted
millionaire but I'm making a statement.
My lord, on her affidavit statement, she is admitted running
Yes.
a petrol pump.
Yes, yes.
I have annexed that affidavit.
No, kindly show from the judgment where you stand. I cannot change the right now by where you have stated that your assertion and your statement.
More statement. Se
leave it there.
Se nije admit kurchan the affidavit.
I'll record that.
Se danka nije admit kurchan the affidavit running a petrol pump.
Just now give me time to dictate because this is not our discussion is leading nowhere. When you are challenging, you are not relying on her statement. Fair enough. I'll record.
On affidavit
Correct,
is
correct.
filing before.
I have understood. I have understood. I'll reflect. You have to give me a chance to reflect that.
My lord.
You take your seat. And take some time in dictating the orders. The husband in the marriage is before this court. The learned counsel for the petitioner was had at some length.
Well, entire
The husband in the marriage is before this court.
May I pardon your lordship?
No, please don't disturb. Please pardon me for completing the order. Then I'll give you time.
My lord.
I'll try to reproduce whatever your submissions are. I'll reproduce in your presence only. So I'm not dictating behind you.
Annex that affidavit, my lord. My lord.
What was
My lord.
the affidavit? Whatever is there is there.
Sorry,
No
my lord.
difficulty. The petitioner before the court by filing the application under section 19(4) of the Family Courts Act. Challenging the judgment dated 24/10/2002 passed by the learned judge, Family Court, Bhadrak stuff. जो 2025 लिख लेनी इन क्रिमिनल प्रोसीडिंग नंबर 212/2023 है the said criminal proceeding 212/2023 was filed by the wife in the marriage along with 2 minor children from the wedlock. Daughter aged about 14 years and son aged about 10 years. Seeking monthly maintenance under section 125 of the CRPC into bracket since repealed by perimeteria provision, since repealed and substituted by perimeteria provision contained in section 144 of the Bharatiya Nagarika Suraksha Samhita 2023. The application was favored and the judgment is under challenge. However, instead of granting 50,000 per month as maintenance for the mother and 2 children, for the wife as mother and 2 children, an amount of rupees 5,000 has been awarded each to the daughter and son.
No, 7,000, 7,000, mother 5,000.
What amount of 7,000 has been awarded to the children, petition number 2 and 3, and the wife has been awarded monthly maintenance at the rate of 5,000, the total coming to 19,000. Stop. It is submitted by the learned counsel for the petitioner. The wife is rich and affluent. She has petrol pumps running, she being the owner. Stop. The submissions made before this court being matters of evidence and pleadings, the learned counsel was requested to refer to the pleadings before the Honorable Judge Family Court where such stand was taken. She was also requested to refer to the evidence that was produced before the Honorable Judge Family Court to support the contentions. Those are made in the present application by the opposite party as petitioner in this case. To the said query, the learned counsel for the petitioner, in response to the said queries, the learned counsel for the petitioner submits that she doesn't have copy of the pleadings of the copy of the objection of the written statement, pleadings, objection and written statement. Of the opposite party before the Learned Judge Family Court. However, she submits that the wife has admitted in her statement before the Learned Trial Court. Examine chief na cross re.
Well, affidavit जो asset liability
has admitted her income.
Page 14, para 5 of the
in the affidavit furnished in the terms of the decision Rajneesh versus Neha. It refers to affidavit paragraph
page 14 of this petition, paragraph 5.
Petition report affidavit paragraph.
Affidavit paragraph 5.
Affidavit
Annexure 1. Annexure 1. Annexure
It
1.
has been annexed to the present revision application. Marked as annexure 1. Who paragraph?
Paragraph 5.
Who page?
Page 14. Internal page 5. Main page 14.
So the cut paragraph 5 the cut. She refers to paragraph capital E. Details of income of the deponent. Did I put it up? Internal page के देना पड़ भूल भाल use.
It's
internal page 5.
Internal page 5.
Paragraph capital F.
Yes, F.
Capital F.
Asset
Internal page 5 of the affidavit. Paragraph 5. So paragraph 5. The said paragraph 5 is reproduced here. We submitted that in view of the statement made in paragraph 5. Should deprive the wife in the marriage for any monthly maintenance as paid for. The paragraph 5 is self-explanatory in nature. That is, the Malik filling station situated at Durgapalli in district Sambalpur is on the land leased by the father-in-law of the wife, the father of the husband. Thereafter, she has executed a sublease agreement in favor of Hindustan Petroleum Limited by spending rupees 40 lakhs from her father. Her maternal property of rupees 4 acres were sold by the stop. All profit and loss heirs or father-in-law, Kirot Chandra Mallik, who is Debabrata, and one Sri Debabrata and Debabrata Mallik, the husband. The response of the husband has been noted by the Honorable Judge Family Court in paragraph 3 of the judgment. Which is reproduced here. Paragraph 3 ta paragraph. Internal page 5 of the judgment, page 25.
Page
Page
29. Internal page 9 sorry.
Interrupt karo se kon hobo ki jeto apon koibe they get confused. They make those mistakes. Both of the internal page, upon the internal page.
Sorry.
When I seek your assistance, please. But they have their limitation. Internal page 5. The following issues have been framed by the trial court. Paragraph 4, internal page 10. Then submissions on behalf of the husband have been noted at paragraph 7 of the judgment. Seven started internal page 13 to MC internal page 50. The evidence of the petitioner have been noted at internal page paragraph 8 of the judgment, internal page 60. The evidence of the opposite party has been noted in paragraph 9 of the judgment. Paragraph 888, paragraph 9. I know the opposite party was there. He submitted on behalf of the opposite party, the petitioner's husband, was the opposite party before the Lord Judge Family Court that
I'm challenging that.
he will continue, he will pay the amount to the children from the Withdrawal who are staying with the mother, but he will not pay any amount to the wife in the marriage. The contention regarding the scope and applicability of Section 125 CRPC has been elaborately dealt with by the judgment of the Honorable Supreme Court in Rajneesh versus Sneha. Paragraph पूरा का कर दिया है. the issue when the wife is capable of earning, oblique employed, and is earning, is also has with whether she is entitled or not entitled for any maintenance during the subsistence of the marriage under section 125 of CRPC. The scope of interference by this court by exercising the revisional jurisdiction in orders in judgments and orders, judgment and orders, granting maintenance under section 125 CRPC has been elaborately dealt with by the Honorable Supreme Court in Shamima Faruqi versus Sahid Khan, Bolor, into bracket 2015 bracket closed 5 SCC 705. Paragraphs 19 and 20. The husband should pay at all the maintenance or not to the wife and child has also been dealt with by the Supreme Court in Rajneesh versus Neha. Paragraphs. And also in Shamima Faruqi. Paragraphs 15, 16, 17, 18. 15 ରୁ 18. The learned counsel for the petitioner to address on the aforesaid issues and the questions of law involved. Yes. Please in the week commencing.
Melu.
Quebec.
Mm. 20 Melu.
The week commencing आज कितने तारीख है?
आज 50.
Week commencing 4 ही 5 को. Commencing 4 ही 5. Yes.
Item 10.
Application.
Has to be rejected. The
One is the delay to not.
outline add कर दियो outline add करते हुए paragraph add. In view of the clear pronouncement of the Honorable Supreme Court in Rajneesh Supra, that amount directed to be paid to the wife is akin to a money decree. Wife and children is akin to a money decree. The petitioner, the learned counsel for the petitioner shall obtain instruction how the petitioner seeks to secure the decree, secure the amount to sustain the challenge before this court. Yes.
Item 10.
Item 10, my lord, this is the case with regard to that jurisdiction, actually, whether section 9 can be heard at the beginning or it has to be heard during the trial after framing of issues, my lord. On the last occasion, Mr. Acharya, my learned friend was not there. Your lordship was of the view.
Acharya, can you agree for a place or you want to continue at that place? That was the for that
No, no,
we
my-
were
my-
looking
my-
for.
I
I
will
would
continue in
suggest
that
because-
place, my lord, because my lord, the child was with me. She was born when I was there with my parents. My lord, I was mentally, physically tortured for demand of dowry. So then I lost a FIR at Fulbani. Then the child was with me. Because my father was a reporter in a newspaper, we shifted to Bhubaneswar. The husband came and forcibly took the child on the ground that you first close this 490-day case. And this is a pressure tactics. And thereafter, I went to the police station there. With the help of police, I wanted to take my child. They didn't allow. They said, no, you cannot also see the child. Well, the child is a female child, aged about 3 years, 7 months at that time. Then, my lord, I filed a custody application here. And the petitioner, before my lord, is coming and raising a question that the trial court has rightly said that evidence should be taken and it will be decided whether the jurisdiction point can be decided at the time of trial. So, the trial court has not rejected. Trial court has kept the issue open. So now my learned senior last has cited such a judgment that Dilip Behra case, I was going through that judgment. My lord, that paragraph 11, paragraph 13, paragraph 18, I am going through. My lord, their lordship has said that ordinarily reside their lordship.
No, actually for fresh admission, it is only listed. It is only listed for fresh admission with a purpose that if you are agreeing for any, so that is what Mr. Acharya is saying.
I am there in my lord.
Mr. Acharya is not agreeing.
What I'm trying to say, without going into the merits of the case for the time being.
And my lord, another thing with my learned senior's permission. My lord, in the I went there to see my child. That they even with the police SD entry was made, and I went there.
No,
I was not allowed.
Mr. Acharya,
My lord,
Mr. Acharya, actually, you must have heard. I was telling Mr. Singh also. These things are happening. These things are happening. So please appreciate.
Just for a moment.
No, please appreciate this thing. Now, suppose I understand. I appreciate your difficulties in meeting your child. Can this court pass any order?
No, my lord. No, not that.
So
I'm
now
asking.
you may be having some anguish over that.
I'm not asking that. I'm not asking
Please
that.
appreciate.
Just 1 minute. My lord, when they said that you don't have an order, we will not allow you to see the child. Then I approached the family judge. Then I asked for an interim custody. Court said that matter is pending here, so I will not allow interim custody, virtually allowing your main prayer. So court has permitted me for a visitation right. But despite that order, I went recently with my father. I was denied. My lord, your lordship can appreciate both father and mother.
Being extremely sympathetic to
both father and mother.
PT, this court cannot do anything.
No, I'm not saying. My lord, your lordship can and mother have.
See, the visualization part of this court is confined to the jurisdiction and other aspect. So I am not adjudicating what should be the terms and conditions.
Your lordship can appreciate both father and mother have equal right over the child. So father cannot.
Acharya, post appreciation, what orders I will pass, I am asking you actually.
No,
I'm a little bit ahead of
my lord. Yes.
So you must understand, sir. Today, since the husband, since the parties are battling it out for the regarding the question of law that whether it should be at the beginning. So now, suppose you agree, is anyone compelling you to agree? It is a question, sir.
No, man.
It's only a question. In that context, it is listed. Otherwise, it has to be heard. So it will go for hearing. You have to hear the matter.
So family court has said.
Is it that I am deciding the matter?
No.
So you must understand that. So
I completely understand. I completely.
May I just make a simple
let the
suggestion,
family
my
court
lord?
decides. As he has said that at the time during trial it can be decided. So
no,
because the evidence has to be laid. Whether ordinarily.
Mr. Acharya, since custody is with you.
Yes.
Yeah, it is with me. And the child is studying at Baleshwar. No, what I'm
to that extent, Mr. Acharya, I mean, both are Mr. Acharya. So at times, actually, while addressing, actually, he is looking at me. So that was so that's.
But he is senior Acharya, I am junior.
So
no, nothing like that. No, may
One
I
is in
just
VC, one is invisible. Invisible
May- may-
Acharya and one is
No, no,
VC
no.
Acharya.
At that time I was, I said frankly, but at that time I had gone to Bhaijak.
Anyway, so that
And I
so
was there in
now since
Simanchal temple.
the senior and the equally senior both acharyas are not agreeing for the place, it has to be hard.
Yes.
So that is the job of the court now.
May I just suggest one thing, my lord, which will be a win-win situation for both of us. I am staying at Baleswar with the son and he's studying there. There is no dispute to that as of now. And in the petition, in one place, he says, I mean, my learned friend says his client is staying at Bhubaneswar, and in another place he says that he is staying at Fulbani. So Bhubaneswar is a common
No,
place.
he said that.
Fulbani, I was
actually,
there.
I mean, that is that. So that may be the difficulty of the, women. So you want it at Baleswar?
No, we can do it at Bhubaneswar. I have no problem.
Like, Bhartan Kuti Chauchandi?
No, no, but Fulbani, I have filed it at Fulbani. So my learned senior is saying that if it comes to Bhubaneswar, then it will be better for him, convenient. So for that I have to obtain instruction.
So more kahwa katha, Mr. Acharya, your client is having the custody.
Correct.
Equally senior Mr. Acharya's client is having only visitation and contact rights and facing some difficulty. So if the matter you agree, at least the matter can proceed. So that was the suggestion.
So let me obtain instruction.
ଆପଣ ଏବେ କୋଉଠି ଚାହୁଁଥିଲେ ଆପଣ ଅବଜେକ୍ଟ କୋଉଟା ଫୁଲବାଣୀରୁ କୋଉଠି ଆସିବେ ମନା କରୁଛନ୍ତି
ନାଇଁ ଫୁଲବାଣୀରୁ ବାଲେଶ୍ୱରକୁ ମୁଁ ମନା କରୁଛି
No, I am agreeable to
ସେଇଆ ମୁଁ ପଚାରୁଛି ବାଲେଶ୍ୱର ଚାହୁଁଛନ୍ତି ତ
ନା ନା
prayer is for ବାଲେଶ୍ୱର
no
senior
his
Mr.
prayer is
Acharya
for Baleswar, yes
senior Mr. Acharya
his prayer for Baleswar.
not
we can
equally
do it
senior
at,
Acharya
we can do it at Bhubaneswar. No problem.
Bhubaneswar, so that at least you can give render assistance to the court. The parties will be happy to have assistance of both of you.
Yes.
In these kind of matters, I mean, for the sake of the child, there should be less acrimonious exchanges with parties.
And
give me a week time so that I will obtain.
And another thing also, with regard to the visitation, which my learned friend is complaining, I'm not aware of that. But if that is so, I'll ensure to this honorable court. I will tell my clients that they should not oppose the visitation.
In fact, that was the precise statement I made because this court cannot, but Mr. Acharya will ensure that is something.
No, I am going out of my way in saying that if that is so, then I'll instruct my clients that they should not oppose to this visitation. That much I can assure.
Because in front of the child, this should not happen.
Exactly.
That has a law, but I mean, it takes a toll on the child.
Exactly.
My lord, if your lordship, this was the order passed by the.
No. Sir, I am not taking of that. There is a method even if it's madness, there is a method in my approach.
Yes.
More contentious issues which should be avoided by this court, it should be left for the trial.
Yes.
So for Bhubaneswar, both of you agree. So I think it will be win-win situation as Mr. Senior Acharya said.
What a weekly time you
ठीक अछि, सेटा ठीक अछि, for that purpose only it is listed.
Yes.
Otherwise it has to go for hearing. Mr. Gautam Kumar Acharya, Senior Counsel, Senior Advocate, along with Ms. Pragya Panda for the petitioner, Mr. Arun Kumar Acharya for the opposite party. आप लिखिए तो typographical error को correction करो. Kindly just take your seat. I'll pass the order. There is a typographical error pointed by the registry. The registry has pointed out typographical error in the order dated order dated 8/4/2026. The order number having been typed as into code 2 instead of 3. The said mistakes are the mistake in typing out the order number is usually happening. Stop. The order number shall be corrected by carrying out the necessary correction in the order sheet in accordance with rules. Para. the learned senior counsel, advocate for the petitioner as well as the learned counsel for the opposite party were heard at some length. Mr. Acharya, should I record Bhubaneswar or I should not?
No,
I understand. I understand. I will not record anything. After hearing both the senior counsel, senior advocate for the petitioner as well as the learned counsel for the opposite party, the court is hopeful that the parties will agree for a settlement regarding the place of prosecuting the matter seeking custody. Taking note of the positive sentiments expressed at the bar by both the counsel for the parties. The matter shall be listed under the heading fresh admission in the week commencing. Week commencing 4-5 Mr. Acharya. Week commencing 4-5-20-26.
And interim order to continue.
Interim order as passed earlier shall continue in the next statement.
I note my learned senior suggestion that he will cooperate.
Yes.
I'll do
That is
that.
beyond.
We
should not complicate. Let us keep it straight, simple and
One
straight.
difficulty will be there because this is a petition. My learned seniors prayer to decide the jurisdiction issue. My lord, if the
Now
transfer that nomenclature will be a transfer petition that he has not said. Case will be transferred from Fulbani family just to.
In the 227 I can do that.
ଆପଣ
ଗୋଟେ ଆଇଏ ଦେବେ କି ମେମୋ ଦେବେ ଆଇଏ ଦେଇଦେବେ ସରିଲା ଆଇଏ ସରିଲା ଆଇଏ ଫର appropriate order joint petition ଦିଅ that supervisory power I do have.
Yes.
But not deciding the matter, that power I do not have. ଆପଣଙ୍କର inter district transfer ରେ High Court can always exercise jurisdiction. ଆପଣ affidavit ଦେଲେ ହବ and it's a writ application ତ.
Yes.
Obviously it is read with 227. During pendency ଆପଣ ଫାଇଲ କରିପାରିବେ. ଆପଣ by next week ଯଦି decide କଲେ please file that application. Sufficient time ଦିଆ ହେଲା.
I will just.
Do you to पूरा complete.
interim order to continue.
Interim order it shall continue till the next date of hearing.
Grateful.
Rest of the matters after recess.
Item number 13, Lord. In fact, the challenge has gone infructuous because of the settlement made on the disputed amount.
Other side ଅଛନ୍ତି?
I'm there on behalf of Mrs. Sahoo.
ସେଟା ଗୋଟେ memo ଦେଖି ଦେଇଦିଅ. I'll dictate the order. I'll make your presence.
No, ma'am. Yes.
Mr. D.K. Mahanti, just 1 second. D.K. Mahanti, Mr. Tripathi.
Yes, ma'am. On behalf of Mrs. Sahoo.
Just file a joint memo.
Yes.
Disposed.
Item number 14. Permitted.
Pardon to mention, my lord, these are the memo and very urgent in nature. My lord, may kindly take up this matter on tomorrow, my lord.
Then, first of all, second happen memo no baka tha no.
My lord, move
all the memos I can't have a more urgent, less urgent. All memos are allowed. These are up to fresh na, up to notice na.
Fresh admission.
They do. Kebele koribe. That much indulgence I can show you. Though the time is over, he will keep it and maybe it will be treated as tomorrow's memo. Line page rakhi debe.
Item 13. I don't have power on behalf of Mrs. Sahoo.
ତାଙ୍କର ନାଁରେ ଆପଣ ଲେଖିଦେବେ just but she should know it.
Yes.
Without her being present, ଖାଲି ଆପଣଙ୍କ ନାଁ ତ ଲେଖିଲେ ହବନି.
On behalf of.
Yes, sir.
27. Speed has not 5 count.
27 କାହା ପାଖରେ ଅଛି list? Counter file by OP3. 6. OP1 file करना है ଆପଣ କହୁଛନ୍ତି. What is your date कर दियो तो why he will wait? He saying it has to is after notice matter. 27 date करियो.
After 40.
We commencing 18/5. Yes.
Item 14. Permitted to withdraw. I am filing the memo.
Yes. That order will be, I'll dictate the order after I resume proceeding. 14 टा लेखी रखो. Item number टा पके देबे. नले mix up हे जियो.
Memorative number 10.
Yes, Ms. Bhagat,
Item 23, your lordship.
23.
Little modification is there.
এই মডিফিকেশনটা যেটা কହୁଛନ୍ତି সেটা মানে আফটার রিসেস ଆପଣ ରହିବେନି?
ନାଇଁ sir, ଏ ଭୁବନେଶ୍ୱର କୋର୍ଟ ଯିବାର ଅଛି।
ନାଇଁ ଆପଣଙ୍କର କଣ ମଡିଫିକେଶନ ଡେଟ୍ ନା କଣ?
ନାଇଁ sir, it is 13B2 instead of 13B1. It has been typographically typed as 13B2. It's order.
13(1)(1)A.
हाँ, 13B1.
13B तो 1 नहीं, 13B ଗୋଟେ provision. Mutual.
हाँ.
तो ମୁଁ ଦେଖିଦେବି. Typographical error तो I'll do.
My lord's order is there, 6/3/2020.
That is there, but I wanted to whether I require your assistance. I'll see that.
My
I'll pass the order.
my lord,
No
my-
difficulty. It will be done. Garanti. What you got special bench ଅଛି? Yes, Miss Pradhan. ମୋତେ ମନେ ପଡିଥାନ୍ତା ନା ଅର୍ଡର ଗୁଡାକ ଡିକ୍ଟେଟ୍ ହେଇଥାନ୍ତା ହଉ ଦେଖିବା other side yes dictation ଦବା ତାହେଲେ ଠିକ ଅଛି let us continue with the the first bench matters dictation କୋଉଠି ରହିଲା
ପାସୱାର୍ଡ ଗୋଟେ
ନାହାନ୍ତି ପାସୱାର୍ଡ ଆପଣ ଦେଖୁଛନ୍ତି ଆଉ କଣ ସମୟ କାଇଁ ନଷ୍ଟ କରୁଛନ୍ତି ଆସିଲେ ପାସୱାର୍ଡ ଡାକିବେ
ଆଇଟମ 13
କାରଣ ସେଟା ପାସୱାର୍ଡ ଫର ଦ ଡେ ହେଇଯିବ ବୁଝିପାରିଲେ ନୋଟିସ କରିନି ମାନେ ସେଟା 13 ତାରିଖ ଥିଲା ତ Mr. D.K. Mahanti for the petitioner. Ms. Susama Rani Sahoo along with Mr. R.K. Tripathi for the opposite party. The matter being in the list is mentioned jointly by the learned counsel for the petitioner as well as the learned counsel for the opposite party. So, Lenka, I'm just continuing with the dictations of the first list till Mr. Palis will ask. Just give me some minutes, few minutes. Petitioner is the electric supply utility represented through its executive engineer and the petition number 2 is petition number 1. The petition number 1 is the petition number associate entity. Petition number 2 is the associate is entity who has some business relationship with the petitioner 1. They jointly have filed a writ application challenging the award dated 02.02.2018 passed by the Permanent Lok Adalat into bracket PUS Public Utility Service bracket closed Dhenkanal dash Anugul at Dhenkanal in ELA case number 19 of 2017. Stop. The said PLA case was filed by the opposite party. Number 2, applicant, challenging the assessment with regard to the amount of penalty of rupees 66,528. Stop. The said penalty was imposed by the petitioner hearing. The opposite party number 2 being the consumer of electricity. The matter was presented before this court on 19/2/2018. Stop. Notices were issued by the coordinate bench by order dated 19/3/2018. And interim order dated by interim order dated 19/3/2018 in Miss Case number 2629 of 2018. The order dated 2/2/2018 passed by the permanent localer was kept in abeyance, was directed to be kept in abeyance. Thereafter, directions were issued by order dated 4/4/2019 for substitution of legal heirs of the deceased OP number 2. This is the OP number 2, who unfortunately passed away during pendency of the petition. So thereafter, another coordinate bench by order dated 4/4/2019 in IA number 5876 of 2019 directed for restoration of supply of electricity subject to payment of rupees 10,000 towards areas with a further direction that the consumers should pay the current electricity dues. The matter was listed on 11/3/2026 under the heading देखिए लिखते हुए जो referral for referral curator. Today, memo of date is filed by the learned counsel for the petitioner as well as the opposite party, which states thus. The memo is taken on record. Accordingly, the writ application is disposed of. The receiving. Yes.
Item 14.
As directed by the order dated 30/3/2026, the efforts of the registry to intimate the learned counsel for the petitioner has yielded. The learned counsel for the petitioner is present. The matter being in the list is mentioned by the learned counsel for the petitioner. He files memo of date. Appears actually with me. Mr. Haraprasad Ratha for the petitioner, opposite party blank. He files memo of date which states thus. ତା ପୂର୍ବରୁ ଯୋଉଟା ଆପଣ ଏଇଟା ଯୋଉ ଲେଖିଲେନି ତା ପୂର୍ବରୁ ଇଣ୍ଡିକେଟ ରିପିଟ୍ କରିଦେବେ order dated 33/2026 one non-appear surrender one non-appear surrender 1 2 3 ତାପରେ today's order এটা দেবে
Item 23,
accordingly the revision application is disposed of. The matter could not reach due to paucity of time. Appearance लिखो Miss M Bhagat, Madhu Bhagat. Miss Madhu Bhagat. Miss immediate Madhu. Not the petitioner. IA 5161 of 2026 has been the heading on. Subheading. Let margin heading. The IA has been filed for correction of the typographical error. That has crept into the judgment dated 6 March 2026. The Lord Counsel for the petitioner, referring to the said judgment, paragraphs 11 and 12 submits that the mention of 13 into bracket capital B into bracket capital 1, capital 2 in the said paragraphs has to be read in the context of the statutorily prescribed period 13-B into bracket English 2, period in 13-capital B into bracket English 2 of 6 months. One. In paragraph 13-B into bracket 2 shall be corrected as 13-B into bracket English 1. Judgment is correction of accordingly the correction shall be carried out in accordance with the rules. If the certified copy, if received by the Lord Counsel, shall be permitted to be deposited again and shall be returned after carrying out the necessary correction at paragraph 13 by mentioning 13-English B into bracket capital B, 13-capital B into bracket English 1. Certified copy का किसी कोई ना है तो The permit, liberty is granted. The IA is disposed of. Yes, next.
Item 27.
Memo recently.
No, sir. Document.
Serially.
No.
Eh?
Interim order ଅଛି।
Mr. Sethi, can you hear me?
Yes, Your Lordship.
Counter not filed.
Counter is yet not filed, Your Lordship.
Mr. PK Rai for the Ray for the petitioner. Mr. Hon'Ble Sethi AC for the state. Lord Counsel for the petitioner submits that counter has not been filed on the P1. Stop. The Lord Additional Standing Counsel submits that the counters will be filed within 4 weeks.
Your Lordship, 4 weeks.
In 4 weeks, the counter will be filed upon serving copy thereof on the Lord Counsel for the opposite party. The typographical error contained in order dated to 28/1/2026. That is, order number shall be typed as 24 instead of 23. 24 quotation and 23 quotation. The necessary corrections shall be carried out in accordance with the rules in the other city. Mr.
35.
A. Sahoo. A. Sahoo for the petitioner. Mr. Sanjay Kumar Panigrai on behalf of AP Bose for the opposite party. The petitioner's husband is before this court. Challenging the order dated 21.05.2024 passed by the learned judge family court for girls. In IA number 06 of 2021, arising out of MAT case, MAT, all capital, case number 81/83 of 2020. Into bracket annexure 9 to the petition. Sorry, sir?
34.
No, sir, the base is not available. Actually, I missed that. So there are some leftover orders to be dictated. So since there is a special bench at 2 p.m.
Yes,
it was actually already posted to
34 minutes.
So the bench is now the court time is over. So since the other matter could not be taken up, the Lord Counsel was not available. So I'm completing the dictation portions of today's whatever was taken.
My matter is 34. So that's
34 ଆପଣଙ୍କ ଯାଇଛି serially କେତେ ଯାଇଛନ୍ତି?
No.
9 ଯାଇଛି। So ବାକିଟା କଣ କରିବେ distribute କରିଦେବେ ଆପଣଙ୍କର ଆଜି ହେଉଛି ବୁଧବାର ତ ଗୁରୁବାର ଶୁକ୍ରବାର ସୋମବାର ଭିତରେ ସବୁଗୁଡାକ ଯୋଉଟା ଆଜି ଲିଷ୍ଟ ହେଇଛି ଯେତିକି ଆର୍ଜନ ହେଲା ଯୋଉମାନେ ମେନସନ କରିଛନ୍ତି ବାକିଗୁଡାକ ଆଡଜଷ୍ଟ କରିଦେବେ I also wished in the while I could not dictate also.
Lordship, I may be pardoned.
Yes, Mrs. Das.
I have 2 items in the weekly list, my lord. One is item number 19 and another is item number 38.
So you want a date or it will be adjusted?
My lord, kindly fix the date, my lord.
19 date kar diyo.
My lord, in item number 19, I am for opposite party.
Nobody has noticed like me that today there is a special bench.
18/5 we can give 18/5
Another one is item number 38, that is the 18/5.
Wait for you. Time fix करिए ना wait करिए just Mr. Sahoo I just take for mention item 19 date करो तो Mr. Mahanti
we can see 18/5
Mahanti पढ़ले पढ़ले Mahanti sir ये सुनंतु नहीं पढ़ले धड़ा ये देखा जी ना just बस्तिले पढ़ले बारे yes 19 18/5 आउटे केते कहले मैं
38.
we can say 18/5
we commencing 18/5
My lord.
Yes, senior Mr. Sahoo.
My lord. Sir, there are 2 RPFMs here, my lords. Item 28. One is RPFM.
Actually, what has happened, they have indicated after the first bench, then it will continue. So no one will wait. There is a special bench at 2 p.m.
Yes.
So they have mentioned like, the other matters after the special bench. So obviously no one will wait. I didn't mark. Now my secretary shows me that it is mentioned. So that's better to fix a time. So item 22,
28, my lords.
28 and
28, two RPFMs are there, my lords. And both the RPFMs.
Date कर दियो. Please after notice.
Again.
So the assignment is such that even orders and fresh admission matters is taking time.
Yeah, no difficulty. Any date you lordship will fix.
Date करो.
11/5
We commencing 11/5.
Again. Specific date कर दे हम.
Sir, specific date देखो जिन 13 days adjust माने matter उड़ा का adjust करे पड़ियो सब.
Again.
Specific date थोड़े judicial order है ला change करी होगी. माने adjust हो करी होगी.
Correct.
But we commencing है ले, he has a discretion in adjusting the. माने he in this list section.
Mid-May summer vacation will mid-May 23rd May I believe. It starts for
11/5
आगे.
After notice में तो पढ़ियो कष्ट टिके होची. Yes.
Actually, it's a short matter. Your lordship, matter judgment, your lordship knows. Termination of marriage that is now upheld by the Supreme Court, confirming decree of divorce. So only thing remanding only for in the matter of permanent alimony, my lords. Now I have come before lordship against the maintenance order. So 125 maintenance. Only my humble submission.
125 has to be adjusted in the permanent.
Exactly. That is the Supreme Court judgment. Rajini's case. There may be different flow of reliefs from different statutes. But one has to be appropriate against the other. That is what essence of
the. That has been remanded to the family court or
family court. Okay. But your lordships.
So please, you should have intimated the. I mean, your instructing counsel should have intimated the other side, or they are not appearing.
Other side, they are avoiding somehow. I'm sorry to say this. One RPF filed by them.
Order stand. Office करें. Office to order second. Order second.
Again.
Because I always you have the liberty of mentioning. So
better.
Yes, madam.
Your Lordship, item 36, Your Lordship.
36. What do you want?
Your Lordship, I need a specific. It's from past 2-3. It has been taken adjournment, Your Lordship. So for a hearing, Your Lordship.
It was there, but she was present, but she had some.
Date may be fixed for final hearing, Your Lordship.
Final, final for 1 day. Whenever a final is held, then now it is adjourned for another day. So it's a mixed package.
We have a karma against maintenance, Your Lordship.
29 week
Yes, sir.
ঠিক আছে ফার্স্ট উইকটা ছাড় দেবেন ভ্যাকেশন র ফার্স্ট উইকে রাখুন
29
হ্যাঁ ঠিক আছে
Blessed.
item 11 my lord
7
Item 17.
17
Inadvertently, the defect could not be removed 1 week time and time to applicability.
So that 1 week after ASU, because I am not for taking up the matters, I am just taking up the mention actually. The time is over. 17 टा गोटे डेट कर दियो.
My lord, item number
Just 1 second.
कौन से 11/5
Earlier हेले आपण को actually ता पूर्व वीक रे से रखी सारले 81 टा. But I am observing after 10 days into the month, the total adjournments is reaching 300. And that's I mean adjournments by judicial order. To that other matters fresh and other matters to be added.
item 16 my lord
25 160 till 160 आपण ए मासे रखछन बाकी
item number 33
पानी रे
my lord 11 item 11 fresh admission my lord
डेट चाहउछन ना कोन
काली
सर फ्रेश आउ अदर्स रे ही विल एडजस्ट जोडा अछि फ्रेश रे आपण एडजस्टमेंट चाहउछन आउट दिनु
no my lord काली कैश
काली रखंतु allow him to adjust
Yes, madam, yes,
बुडा तो रखि रही
no losses madam
काली ऐसे ही पारे मु जान
Yes, madam.
लेकिन काली टू शुक्रवार भीतर एडजस्ट कर दियो
no bless
चला
no bless
Item 26 my lord.
सर पुष्टि
item number 33 let it become 27
33 डेट कर
वो कौन से 11/5
Item 26
मोर कोटा एडजस्ट करिया लिखि रखछन जी ता एग्रीमेंट से
item 26 my lord.
26
My lord.
interim stay
इंटरेस्ट के माने कोन
further state ଅଛି further
adjournment अछि ना स्टे अछि
state ଅଛି
स्टे ते टच हो no I am not touching any passing any 26
My lord. Tomorrow my lord.
ए tomorrow रखो ता आफ्टर नोटिस सेंटी कले केमति ऑर्डर्स मैटर अछि
Execution has been filed in the lower.
नोटिस के भी आसपर से कहि दे के भी
11/5
11/5 ले हबो
Sorry, my lord. Please.
27 तारिख को नहीं अरे प्लीज कथा नहीं possibility of reaching the matter is important
My lord.
24 से 100 रखछ हाउ कर
Item
already 100 have been posted 27 तारिख विक्री रखो आपण
Item 36.
36 बड़े की मेंशन करले ना कोन
33
36 मिस्टर दास मिस सरकार तो डेट करछन
वो कौन सी 29
29 24 yes
item 16 my lord
16
yes your lordship any date may be fixed
कौन चाहछन सर
my lord after a date may be fixed
टोल डेट कर
वो कौन से 11/5
bless
Item
yes madam
Yes, Your Lordship. Lordship, item 37. I am for the petitioner, my lord. It may
what a
find-
date
Yes, Your Lordship.
37 डेट करो
18/5
तो 5
My lords.
admission matter
My lords, deeply obliged.
Item 21. There is a delay in limitation.
yes na order se asu I have completed the list actually I didn't notice that 2 pm रा आउट बेंच अछि 21 टा गोटे ऑर्डर्स पे के बेस करियो
11/5
11/5 रे हबो yes 25 ऑर्डर से अछि पर डेट कर दियो
वो कौन 4/5
4/5 अपन डिटेक्शन कौन बोलते 35 अपीयरेंस लिख लो और कौन रखिए ऑर्डर number 6 of 2021 arising out of matter number 81-83 of 20. The I was filed in an application. I was filed on 22/4/2024 by the wife in the marriage seeking maintenance pendant light said application was disposed. The order disposed, the portion of the order disposing of the IA is reproduced herein. In view of the order of Honorable Court 280, the page 55 range. In view of the order, is rejected. Thereafter, the Learned Judge Family Court Borgard has proceeded to finally hear and dispose of the CP by judgment dated 12/3/2026. Memo is filed by the Learned Counsel for the petitioner, enclosing photocopy of the judgment rendered by the Learned Judge Family Court Borgard. The ordering portion of the judgment is reproduced herein, page 13. In view of the above, nothing survives for adjudication in the present writ petition. The writ petition is post of according. Yes, yes, Pradhan. Yes, please, Pradhan. Specialist 2 PM.
Minutes date for 23rd April.
Sri Lanka? I'm not sure. The 23rd and देखो तो कौन डॉक्टर से जोटा पर्सनल अफेयर्स डिस्पोज ऑफ जजमेंट है तो रहनोतला पर्सनल जोटा अफेयर करथिले दैट डे मिस्टर लेंका इट कंटिन्यूड टिल 3:50 तने आपण मैट्रिमोनियल मैटर तो आसोस डिफिकल्ट पिटिशनर निजे आर्ग्यू कले जा हुए कस्टडी माने कांटेक्ट एंड विजिटेशन कस्टडी पेंडिंग अछि जाओ स्कूल एडमिशन हे गला सेविंग ग्रेस होछि मिस्टर Ansuman Chetty was present also.
Yes, sir.
That judgment I have, the child took admission in KIT International School. So every day after school hours, he will have one time play hour with the father. Hopefully they will stop fighting.
Yes, sir.
Because earlier the child was in the play school. Play school re thila, to adhika samay thila, bartan to school jibo.
Similar judgment this honorable has passed when Mr. then Honorable Justice A. Pasat was acting. Other side was Ramakant Mahapatra Senior and Ashok Mukherjee.
Oh, I mean the greatest.
Yes,
greatest Odisha High Court has seen.
Yes.
Including the Honorable Judge also. But anyway, it is the pending actually, but nowadays, I mean, parents have a different problem actually. If you are 2 PM. The matter actually WPC 31548 of 2025. 2 PM discharge. The matter is in the special list marked at 2 PM. Appearance Mr. Subir Palit along with Miss A. Pradhan for the petitioner, Mr. Ian Lenka. Additional advocate for the opposite parties. The petitioner, the Learned Counsel for the Learned Instructing Counsel for the petitioner mentions regarding personal difficulty of the Learned Senior Counsel for the petitioner and 6 for adjournment of the matter, 6 for adjourning the matter to another date. Please kotha dekhile. कौन अच्छे तेईस आपणकर मैटर केते पोस्टिंग करछन्ती किछि असुविधा अछि कि दीटा बेले
ना दीटा ना
another date on consulting the learned AGS he suggests for April 23rd 23/4/2026 Accordingly, the matter shall be listed in the special list marked at 2 p.m. on 23/4/2026.
Only I mentioned that this Supreme Court deadline was the 31st March.
I know. But since the other day I understood that in your presence, Mr. Palit says that they agree for the order already for disposing of 3 applications. Only difference is that those 3 applications are appealed. These applications are against pending applications.
That your lordship. And in that order, the Honorable Supreme Court has stated that even if the main writ petition is not could not be disposed of, then interim application for vacation of stay.
Yes, I have noted. In fact, my order I have reflected also. But what can be done? I mean,
my land
they will and operated. So I mean, those things.
My land senior should take.
Yes. It is submitted by the Learned AGA that adjournment should not be granted as the Honorable Apex Court has passed orders the matter to be taken up.
By 35 pounds.
Suggest please. Interim order passed earlier shall continue till the next date. Next date of hearing. AG was to appear.
No, other day.
But I think Mr. Palit suggested that it can be disposed of. So I thought that maybe for some other reason it is getting adjourned.
No, both of them were engaged in on Justice Behra's court.
Only 2 and 3 were appearing. Mr. Leka, both 2 and 3 were appearing.
Yes.
All the 3 matters.
All the 3 matters.
Okay.
Only one point out.
Yes. But in all fairness to both the sides, it should be decided first by the authority.
Appellate.
No, here the original side. It appeal jaini.
No, appeal jaini.
Tinta appeal judge.
No, you
original authority pakare bane OPID pakare OPDR authority.
No, OPDR authority collector has already confirmed the order demands.
Appeal
achi, but your lordship other day suggested to go for an appeal because Mr. Lenka's case.
Yes.
That matter was remanded to RDC as appellate authority.
Correct.
Your lordship has.
I have given the number also. I have given a time frame. The pleadings will be completed. They should be dead, and also they have to mention before the court that such and such order has been passed by the Honorable Apex Court. Suppose he is a party before the court or in any proceeding, Honorable Apex Court have noted that this regarding this case. So that also have added clarified. You can kindly see that order.
Yes, I am having that. Okay.
Mr. Palit said he doesn't have a copy. Later on, he obtained and he said that yes, I have seen. अब पास ओवर कुछ रहेला पास ओवर को एडजस्ट कर देंगे दैट इज पास्ट ओवर फॉर द डे है ना अब कॉल करी होगा